You're having problem here.
That's audio.
I'm trying to get the audio. I'm connected to the audio. Connecting to audio. I think they're having problem connecting to the audio. Connecting to audio. And these are our people. Video call. No, how about this one? This one gets them in a to see. Can't get the system. I don't care. I just made some more than I'm afraid of. I'm afraid of. You haven't gotten the audio.
Can you hear me, gentlemen?
I think they're having problems. That's why I'm asking them that they're having problems.
Yes, my lord, we can hear you.
Yes,
Can you
yes,
hear me?
yes, my lord. Yes, my lord.
Okay. Thank you very much. The court is called to order, and we are starting with the ruling of Ms. Happy Uche Ike and Action Energy Limited and one other. Can I take your appearances, please?
May you please, my lord?
Appearances. Yes.
I am Samson Abba. I appear for the claimants, my lord. Claimant respondent. My lord, the claimant respondent is in court.
Very well. Yes, for the applicant. Who is for the applicant?
I think they can't hear you. They are actually online, but I think they're having issues with their connection.
With robust respect, my lord.
Yes.
PG, double, with robust respect, my lord.
Yes.
We are hearing you, my lord. We are hearing, sir. With me,
But you have not
M.I.
announced your appearance.
M.I. Oshemele. I am G.G. Okoro, double G. Okoro.
Yes. Yes.
Double
I got that. With who? With who?
G as for defunct Bongola. With me are M.I. Oshemele. M.I. Oshemele, Esquire. And Lucky Oyibo, Esquire. We are for the defendant applicants.
Okay. Very well. This is my ruling. The application of the defendant's applicants brought pursuant to Order 17, Rule 1, 4A and B of the Court Rules, Section 18 and 21 of the Limitation Law of Delta State of Nigeria, Cap 127, and under the inherent jurisdiction of this court, praise the court for an order of court to strike out or dismiss this suit for want of jurisdiction, and for such further order as this court may deem fit to make in the circumstance of this case. The grounds upon which this application is brought that this suit is statute barred by virtue of the provisions of Section 18 and Section 21 of the Limitation Law of Delta State, Cap 127, Laws of Delta State, and that the action is brought after 5 years. I have carefully considered the processes and submissions of the parties. Order 18, Rule 2, Sub-Rule 2 and 3 of the court's rules provides thus, quote, where in a matter before the court, a defendant wishes to dispute the jurisdiction of the court to entertain a matter, the defendant may, by a motion on notice and an affidavit disclosing the facts in support of the application with a written address, apply to the court to hear and determine the motion. Where an application made in line with the provisions of Sub-Rule 2 of this rule, the court may take such application together with the claimant's substantive suit. In matters such as the instant suit, courts are enjoined to state their opinion regarding the merit of the case. Should it be that on appeal, the court is wrong in striking out the suit. This is to enable an appellate court to benefit of the trial court's decision on merit, just so that the precious judicial time is not wasted in a retrial, should the verdict of striking out be obtained on appeal. That's the decision of the Supreme Court in Feed and Food Farm Nigeria Limited versus NNPC. The citation is supplied. In this case, Nikki Toby, JSC of blessed memory, had this to say, and I quote, any court below the Supreme Court is in order to take in the alternative the merits of the matter after coming to the conclusion that it has no jurisdiction to hear the matter. This is to make sure that the case is not further delayed if the appellate court comes to the conclusion that the ruling on lack of jurisdiction is wrong. Accordingly, I am of the view that it is good wisdom on the part of the Court of Appeal to take the other issues in the appeal after coming to the conclusion that it had no jurisdiction to hear the matter. Close of quote. On the strength of Order 18, Rule 2, Sub-Rules 2 and 3 of this court's rules, that is NICN Rules 2017, NICN Rules 2017, and the Supreme Court case of Feed and Food Farms Nigeria Limited versus NNPC Supra, I shall proceed to hear this case on its merits and make a determination of the preliminary objection in the course of and as part of my judgment. That ruling is read and delivered in open court, and there shall be no order as to cause. That is my ruling.
As God pleases.
As God pleases.
We are grateful, my Lord. We are grateful, my Lord.
You're welcome.
My Lord, sorry, just to ask. I actually understand the call of the strike, so I don't know if we'll get dates now or we'll wait and get dates later when the court is fully sitting.
As soon as the strike is lifted the registry staff will send hearing notices to you on the date for hearing.
My lord. Thank you very much, my lord.
If both of you are agreed on a tentative date, you can give it to us. But if you don't have any tentative date, because we can't look at the register now to determine when anything can be taken. So we'll send hearing notices to you. We will send hearing notices to you as soon as the court reopens formally. Is that okay?
Yes, my lord. It's okay.
God please.
Very well. Thank you very much.
Thank you, sir.
Grateful, sir. Well, grateful, sir.
Yeah, you're welcome. The next case is the judgment in Mrs. Mabel Kachi Uzoegbo versus the Attorney General of the Federation and 3 others. Can I have the appearances in this matter?
May my Lord be
Mabel Kachi, yes.
May my Lord be pleased. My Lord,
Yes.
I am Kingsley B. Ete. My appearance is for the claimants.
Very well. Who is appearing for the defendants?
My lord, may it please my lord.
Yes.
Honorable Lord, Nwokoro EE is my name.
Yes.
Assistant Director, Federal Ministry of Justice.
Yes.
Appearing with me, my lord, is Nnemeka Anika, Nneamaka Anika. Nneamaka Anika, my lord. Should I spell my lord? N-N-E.
I got that.
Very well, my lord. Principal State Counsel, my lord.
Yes.
Our humble appearance, my lord, is for the defendants.
Principal State Counsel where?
Federal Ministry of Justice, my lord.
Principal State Counsel.
Principal State Counsel, Federal
You didn't
Ministry
say
of
that. Okay.
Our humble appearance, my lord, is for the defendants.
Very well. This is my judgment. This is a transferred matter from the Federal High Court of Nigeria. The claimant commenced this action on 12 June 2006 at the Enugu Judicial Division of the Federal High Court by the writ together with a statement of claim and other originating process. By leave of court extending the time, the defendants entered appearance and filed their defense processes. Upon the transfer of the case to this court, the parties filed their amended processes. By the complaint and amended statement of claim, claimant is praying for 4 reliefs, namely, a declaration that the purported retirement of the plaintiff by a letter dated 17th March 2006 by the third defendant was wrongful, premature, suffused in malafide, ultra-virus, unconstitutional, null and void, and contrary to the extant public service rules and government-approved criteria for right-sizing in the civil service of the Federation and of no effect whatsoever. an order nullifying statement of the plaintiff as a staff arrears and other entitlements due to her from the time of the said retirement till date without loss of seniority. Three, an order of injunction rehearing with the employment defendant until she is due for retirement with the public service rules. Can you hear me?
No, my lord, is breaking.
It's breaking, my lord. I think it's from your
Yeah,
side,
it's
my
breaking.
lord.
No, it's network. It's not my side. It's network. It's network.
Yes, my lord, it's network. I agree. As God pleases.
Yes, you can hear me now.
Yes, my lord.
Yes, my lord.
Okay. I have carefully considered the processes and submissions of the parties. I start off with a preliminary point. At trial, learned counsel for the defendants objected to the admissibility of the 22 exhibits, that is exhibit CW1/1 to CW1/22 and CW2/1, CW2/2 and CW2/3 is sought to be tendered by claimants counsel on grounds that they are all photocopies are not certified true copies with the exception of letter from Naseni. Learned counsel for the claimant, on the other hand, also objected to the admissibility of 14 documents marked as exhibits DW1/1 to DW1/14. Both parties were ordered to incorporate the grounds of their respective objections for the court to make a determination it is settled law as stated by the Supreme Court in a plethora of cases, including Ogunsoya versus the state and Niger Construction Limited versus Okugbeni, that addresses are to guide and assist the court in the determination of the issues in a case. Where the issue of admissibility of exhibits tendered in court by both parties are not included in the parties' final written addresses for a determination as ordered, it is taken as abandoned. I take it that both parties, aside exhibit DW1/2, have abandoned their objections on admissibility of exhibits. I so hold. In arguing issue 1, In arguing issue 1, the defendants had, per paragraph 3.2 of their written address, submitted that the claimant's retirement was proper based on the facts of this case, law, and evidence adduced herein, that the claimant was retired in line with the public service reform program of the federal government aimed at restructuring, right-sizing, reprofessionalizing, and strengthening of government and public institutions based on the approval of the Honorable Minister of Science and Technology. See Exhibit DW1/2. That claimant, among others, was found to be within the criteria for right-sizing as provided in a circular sent to the second and third defendants for implementation. The defendants went on that under cross-examination, claimant stated in court that she knew about the right-sizing policy of the federal government. The claimant, like others that were affected by the policy, had history of queries as a result of absenteeism, lateness, quarrelsomeness, and gross misconduct. Defendant cited exhibits DW1/3 to DW1/9, 11, 12, and 13. The defendants continued that the claimant's poor attitude to work continued even after she was warned by her superiors, that she rather resorted to colluding with a few members of staff to create an unfavorable working relationship with their superior, which is inimical to public service. That as a result of the claimant's tendencies, an administrative panel was set up by the Federal Ministry of Science and Technology and Center for Adaptation of Technology, CAT, OCA, now Electronic Development Institute, LD, OCA. See Exhibit DW1/3 and DW1/4. They also cited Nimasa versus Ode, Kiraya versus Tambi, IBTC and others, and Cadbury Milk PLC versus Oni, citations supplied. That the act of the claimant in this case clearly showed that there was no trust and confidence existing between her and her employee. In reaction, it is the claimant's contention that her compulsory retirement or removal from the service of the fourth defendant was barred in law and in fact, that contrary to the submission of the defendants, her employment enjoys statutory flavor, that the implication of this is that her employment is governed by some laid down laws as contained in the statute that established the agency that employed her. Cited Olorun Toba Oju versus Abdurrahim, citations supplied. See also section 11, sub 3 of Nasani Act, that exhibit DW1/14 cannot avail any defense to the defendants as the said exhibit draws its strength from exhibit DW1/2, which by the claimant is ultra vires the defendants. That the reliance on exhibits DW1/3 to 9, 11, 12, and 13 proves that the defendant's case is weak, hollow, and lacking in substance. The reliance on the said exhibit shows that defendants have no justifiable reasons for retiring the claimant. Rather, her retirement is a clear case of vindictiveness and victimization masterminded by the then director of the fourth defendant, late Dr. F.C. Obi, for doing her work well as an internal auditor. That from the law as captured in the statute that governs the existence of the third and fourth defendants, it is clear as crystal that the defendants jettisoned the Nasani Act. That from the law as captured in the statute that governs the existence of the third and fourth defendants, it is clear as crystal that the defendants jettisoned the Nasani Act in their desperate bid to retire the claimant. That it is therefore clear that the claimant's retirement by the defendants is unlawful. In issue 2, whether this honorable court can rely on Exhibit DW1/2, same not having been signed, claimant submitted that it is a document of doubtful origin, as it is an unsigned document, that it does not bear the masthead of any of the defendants, that aside not being signed, it was not addressed to anybody, that this gives the claimant cause to worry that the said document which the defendants make a heavy weather of might not after all contain what it is purported to contain, and that it would not be out of place for this court to ignore Exhibit DW1/2, as same does not have any evidential value. Cited Umaru Garo Nigeria Limited versus EP Engineering Nigeria Limited, and Alpha versus Zachary, and Garuba versus Quara Investment Company Limited. Citations are stated herein. Court's records indicate that page 446, indicate at page 446 of the process file B that claimant's motion on notice dated 12th January 2021 and final written address dated 8th January 2021 were duly served an original copy of hearing notice received by learned counsel for the defendants, Woklo EE, on 20th January 2021. Having been served with the claimant's final written address, one would have expected that learned counsel would file his reply on point of law, if any, especially having regard to claimant's issue 2 on whether this court can rely on Exhibit DW1/2. I have perused the entire process file, but I am unable to see the defendant's reply on point of law. I looked at Exhibit DW1/2. It is an internal circular from the Honorable Minister, Federal Ministry of Science and Technology, Personnel Management Department, to all directors, all DGs/CEOs, and heads of units. It is dated 29th April 2005 and titled Criteria for Right Sizing. It is titled Criteria for Right Sizing in the Federal Ministry of Science and Technology Parastatus, Streamlining and Rationalization of Staff. The internal circular states, and I quote, I am directed to forward herewith the approved criteria for right sizing in the Federal Ministry of Science and Technology Parastatus, Streamlining and rationalization of the staff for your immediate implementation. Close of quote. The director, personnel management, signed the internal circular for the Honorable Minister, Federal Ministry of Science and Technology. The criteria for right-sizing in Federal Ministry of Science and Technology parastatals, streamlining and rationalization of staff is then attached to the internal circular. It indicates the category of officers that shall be laid off and their terminal benefits to be paid accordingly. Wancho versus LM, Aiki versus Idowu, Sarai versus Haruna, all citations supplied, all heard that any document which ought to be signed and is not signed renders its authorship and detergent versus ASEAN and others, citations supplied. It is the law that unsigned and undated document has no evidential value. See also Ogudu versus the state, Omega Bank Nigeria PLC versus OBC Limited, Bode versus Mubi Emirate Council and others. The law nevertheless focuses on any document which ought to be signed and is not signed. Exhibit DW1/2 is an internal circular from the Honorable Minister of Science and Technology to all directors, all DGs and CEOs, and heads of units. The internal circular is duly signed and dated by the Director, Personnel Management for the Honorable Minister. The annexed document is, in my considered, an appendage to, which is meant to guide the people on the internal sign. I so hold. The internal circular, which ought to be signed, in my contemplation, has been duly signed by the Director of Personnel Management for the Honorable Minister. The internal circular will be signed, and as such, it is admissible and has evidential value. I so hold. I therefore see no merit whatsoever in the argument of the claimant that the issue of signature and date of Exhibit DW2 as far as the instant suit is concerned, and so it is accordingly discountenanced. The claimant's argument that the procedure for discipline of staff of the fourth defendant as stipulated or captured in paragraph 6 of the second schedule of Naseni Act should be followed or complied with by the defendants in the claimant's disengagement missed the point of Exhibit DW1/2. Whereas the procedure in Schedule 2, Paragraph 6B, 1, 2, and 3 of the Naseni Act has to do with all disciplinary cases of senior members of staff below the rank of deputy and assistant directors, and the role of the Internal Management Committee of the fourth defendant and the Board of Directors of fourth defendant, the right-sizing exercise contemplated is the exclusive prerogative of the Honorable Minister of Science and Technology. In Psychiatric Hospital Management Board versus Ejitaga, citation supplied, the Apex Court held per Uwaifu, JSC, that the act of summary dismissal / compulsory retirement must be done within the law by the appropriate authority under the Pension Act. And by Comptroller General of Customs and Others versus Gusau, the Apex Court per ECHO, JSC, added that the main object and intention of the Constitution investing in the Federal Civil Service Commission the power not only to appoint persons to offices in the Federal Civil Service, but also to make rules regarding the manner they retired or the manner they are compulsory retired therefrom are clear. See also Ekeagu versus the Nigerian Army and another. Citation supplied. Analyzing the provisions of compulsory retirement, the Supreme Court of India in Baldia, citation supplied, held thus: the order to retire must be passed only by the appropriate authority. That authority must form the requisite opinion, not objective satisfaction, but objective, bona fide, and based on relevant material. The requisite opinion is that the retirement of the victim is in public interest, not personal, political, or other interest, but solely governed by the interest of public service. The right to retire is not absolute, though so worded, close of quote. It needs to be emphasized that public interest is the safety valve of making such orders of compulsory retirement so that no arbitrariness or bad faith creeps in. Public interest is the precondition for the exercise of the power to compulsory retire a government servant to be constitutionally valid. Reiterating the point, it was heard in Raju versus State of Orissa, citation supplied, thus, quote, it is thus settled law that though the order of compulsory retirement is not a punishment and the government employee is entitled to draw all retirer benefits, including pension, the government must exercise its power only in the public interest to effectuate the efficiency of the service. The dead wood needs to be removed to augment efficiency. Integrity in public service needs to be maintained. The exercise of power of compulsory retirement must not be a hound on the public servant, but must act as a check and reasonable measure to ensure efficiency of service free from corruption and incompetence. In an appropriate case, there may not be sufficient evidence to take punitive disciplinary action of removal from service, but his conduct and reputation is such that his continuation in service would be a menace in public service and injurious to public interest. On consideration of the totality of the facts and circumstances above, government should form the opinion that the government officer needs to be compulsory retired from service. Before exercising the power, the competent authority must weigh pros and cons and balance the public interest as against the individual interest. On total evaluation of the entire record of service, if the government or government authority forms the opinion that in the public interest, the officer needs to be retired compulsorily, the court may not interfere with the exercise of power, but in its exercise of judicial review to consider whether the power had been properly exercised or is arbitrary in retiring the government officer compulsorily from service, close of quote. Exhibit DW1/4 is the report of the administrative panel on the Center for Adaptation of Technology, OCA. It is dated 26 April 2002. Upon receipt of the said report, the Honorable Minister of Science and Technology approved the recommendations of the panel for implementation. 2 of the 5 highlights of the report are that A, appropriate disciplinary measures, including warning letters against the 5 main culprits as listed in paragraph 5.02 of the report. That is items 1 to 4 and D. The noticeable problem of and D, the noticeable problem of general indiscipline, including absenteeism and lateness to work, should be corrected by way of ensuring strict compliance with the signing of the attendance register by all staff, excluding the CEO. The panel recommended in paragraph 5.01 of the report that, quote, the staff of the CAT, especially those employed during the tenure of Professor Chijioke, should generally be strongly advised to cooperate with the present administration of Dr. E.C. Obi and desist from the pull you down syndrome, because such attitude will only lead to the institution of disrepute. Close of quote. In paragraph 5.02 of the report, it is recommended that, quote, the gang up group made up of Engineer C.B. Mbachu, Mrs. L.N. Nzewoku, Mr. L.E.D. Icheke, Mrs. Mabel Udzebu Ni Achu, claimant in this suit, and Mr. Jones Ekwenugo should be sanctioned. Claimant this suit and 2 others see management and to desist from discord and disharmony among the staff in the longer public interest to retire such a person prematurely based on the employer's established criteria. Sishabe versus Attorney General of the Federation, Utomudo versus Military Governor of Bender State and another, and Isiebore versus NEPA, citations supplied. Having considered the facts of this case, the law and evidence adduced by both parties, I am satisfied that the claimant's retirement was lawful, and I so hold. Regarding whether the fact that the claimant allegedly received what the defendants called severance package validates the claimant's retirement so as to stop the claimant from bringing this suit, claimant argued that the mere acceptance of salary in lieu of notice by the employee cannot validate the invalid and void act of the termination of the claimant's employment done contrary to the stipulation of the Nasoni Act. He cited Al-Hassan versus ABU Zaria, that she collected terminal benefits at gunpoint, that on the authority of Al-Hassan versus ABU Zaria, Supra, such acceptance cannot validate the invalid and unlawful termination of her contract of employment. The defendants in reaction maintained that the claimant, upon retirement from service of the fourth defendant, was paid 3 months' salary in lieu of disengagement from service. See Exhibit DW1/14. That all through her testimony and deposition, claimant did not show any other entitlement that was due to her and was not paid. NNPC versus Clifco Nigeria Limited, citation supplied, is quite forceful in holding that a claim for special damages cannot succeed because it is admitted as special damages are never inferred from the nature of the act complained of. They do not follow in the ordinary course, as is the case with general damages. They are exceptional and so must be claimed specially and proved strictly. A claim for special damages succeeds on compelling evidence to justify it and not on the sums claimed appearing reasonable to the court. See also Anyanwu and others, versus Uzowaka and others. Citations supplied. The law is now well settled. Once he accepts payment, up for him to complain that his employee versus Nigeria is limited. Additionally, Julius Berger, Nigeria PLC versus Mwagu, said that where an employee receives his terminal benefits after his employment is brought to an end, he cannot be heard to complain later that his contract of employment was not properly determined because the acceptance of payment by the employee renders the termination mutual. See Morohum Fola versus Kwara College of Technology, Denny versus Governing Council of Yaba College of Technology, John Holt Ventures Limited versus Okuta, Ilo Abache versus Phillips, Etim Okon Ante versus University of Calabar, and Umo versus ITGF, which held that where an employee accepts salary in lieu of notice of termination of his employment, he may not be heard to complain later that his contract was not validly and properly determined. The actions of the claimant show an acceptance of her compulsory retirement. Her claim of collecting her terminal benefits at gunpoint has not been validated or proven by credible evidence adduced before this court to merit any consideration. I so hold. In the circumstance of all that I have said, relief number 4 must fail. It fails and is accordingly dismissed. Now, nowhere in Exhibit CW1/4 is it written that the claimant was retired for any wrongdoing, and as directed by the Director General, Chief Executive of fourth defendant, the claimant was paid 3 months' salary in lieu of notice on 17th March 2006 in accordance with extant regulation. The claimant accepted this and lived with it for 3 months before she decided to contest her retirement in court. The claimant cannot eat her cake and have it. The truth of the matter, however, is that it is not even material in the circumstances of this case whether or not the claimant's retirement was wrongful. The fact is that the claimant accepted her retirement. As such, it is not open to her to come to court, as she has presently done, asking for her reinstatement or payment of all her arrears of salaries and other entitlements to date. I accordingly see no merit whatsoever in the case of the claimant. The claimant's case fails and is accordingly dismissed. Judgment is entered accordingly. Judgment is entered accordingly, and I make no order as to cause.
As court pleases.
As God pleases.
My Lord, we are so grateful for your erudite judgment. My Lord, I must confess, I've learned so much from your judgment. So much. I'm so humbled and I've learned so much. I'm so grateful, my Lord.
We are grateful, my Lord.
Thank you very much, my Lord.
You're welcome. Both of you are welcome.
That's why I don't want to. I already suspecting a problem. I was already suspecting a problem. That's why I didn't want to.
See what he did in this one? He went deep.
Yes.
Like,
Because he knew we find appeal now.
Yes. Look at the exhibit he's admitting. While in your own, he rejected it.
Well, he said that there was no argument on it. That's the reason.
No, there's argument. I mean the criteria for excising.
Okay.
In your own, you rejected.
There was nothing like that. Nothing like that. But he's going deeper. Does he make any?
He's trying to protect himself.
Yeah.
Because maybe he didn't think that he would go for an appeal.
Yeah.
So discovering that you go on an appeal. You know, the other one was just over 11 pages or so.
Just one small something. I was wondering what.
So this one,
how to give judgment.
I think the other in your own there was a relief he granted.
Yes, that they didn't follow the same. But now he's denying it.
Now he
says it's not for retirement or like sizing.
Yes.
It's for retirement. What does that mean?
So now he appears to be annoyed because of the appeal. So he decided to dismiss this one.
Are we not under Nassim? So how can you now come and say that it's not, it doesn't hold? And I say the act does not hold at all. It's for, I don't know, he mentioned something.
That the honorable
disciplinary is for disciplinary.
Yes.
Now this one is not disciplinary. And this one is sizing. What do you call it? Professionalism and all that. So it's not disciplinary. Is he separating the two? Anything you are doing.